Hey, everybody, and welcome back to the Legal Weekly Wine, where we discuss the week's hottest legal topics. Up this week, we have got the oral arguments in front of the Supreme Court for privileged immunity for presidents. This is the case of Trump versus U.S., where we are arguing in the obstruction case, the election interference and obstruction case, the federal one brought in D.C., by Jack Smith, prosecutor Jack Smith. And the overarching issue is, can he be tried at all? Are his actions, just for the fact that he is president, are any or all of his actions subject to immunity, whereby he cannot be prosecuted? This is the crux of the argument of what is happening in the Supreme Court. And those oral arguments have just happened. We've been waiting for them on pins and needles for a long time. They've occurred. We don't know when the opinion will come out. But what we want to do in this episode is break down what was said in the hearings, how the justices responded, what the justices asked, and what we may be looking at for a result, what we think they might conclude. I'm Virginia Tehrani. I am the owner and attorney for Tehrani Law, LLC, doing business in Maryland, Virginia, and D.C., because you never need a lawyer till you do. I'm also the owner and CEO of The Law Unscripted, which is a legal educational site doing free podcasts, including this one, the Legal Weekly Wine, and our other podcast, The Law Unscripted. And right now we do have materials. We have over 50 different products for the 8 core subjects for law students, including constitutional law. And we've talked a lot in that series, including Dr. Weil, who's a co-host, and Chelsey Rogers and I walked through most of that series together. So check that out. Like our channel, subscribe so that you can continue to follow us week by week, because the news continues to change. And honestly, in 2024, this is a monumental year for legal issues, legal precedent. Donald Trump, whatever you think about him, he has caused so many legal issues that are coming up that are going to be making precedent, that have already made precedent. We can't escape it, and we are on the crux of one of the biggest years in history, our history, for legal issues and precedent. It's a lot of political, of course, but we're on the legal side. Politics comes in. And I am delighted to have my co-host, Chelsey Rogers, who's also an attorney with Tehrani Law, and our co-host for The Law Unscripted. Welcome.
Hey, I'm glad to be here. Shocked that we're still talking about Trump, all these years later, but here we are. And I think this one's interesting because we're talking about sort of Supreme Court and precedent, and this is a pretty new question, I feel like.
It is, and I think everybody's saying that this is new. This has never been done before. We've never had a president in our full history to be criminally prosecuted after his presidency, and we're all grappling with what do we do with it. I'd love to, be the decision maker. I think a lot of us would love to be our own decision maker, but it's not up to us. It's up to 9 people on the Supreme Court. And this is why we have a lot of talk about stacking yes. of the Supreme Court, the politics of, are they Republican, are they conservative or liberal? Because they were placed there by Trump, will that affect things? Will that go in his favor or not? So all of these things are underpinning this case. So that leads me to Dr. Weil, who's our third co-host. As much as I love Chelsey, and she and I will forever be, continuing to work together, Dr. Weil, especially for this episode, we're thrilled to have you. Dr. Weil is thank you. You're the one helping us out on this podcast, and it's great here because you're the dean of the Honors College at Middle Tennessee State University, but your underlying expertise is teaching, is a professor and a researcher, a scholar. And you are a scholar in and an expert in the Supreme Court.
May I make a little advertisement for a minute?
Please. Oh, my goodness. I can speak your praises all day long. Please add.
No. So I am revising a book called A Companion to the U.S. Constitution and Its Amendments.
Yes.
This is 7th edition. I'm in the process of writing the 8th edition, and we're going to put a subtitle with it called America's Continuing Revolution, because
wow.
because we're excited about the semi-quincentennial 250th anniversary
Of
of the
America.
Declaration, which is coming in 2026. And generally, I wait about 5, I think, let's see, first publication I did of this, I believe, was in 1993.
Wow.
And we've done 7 editions. So generally they'll publish it in hardback one year and then paperback in the next year. And it's only been, I think, 4 years since the last edition. And my publisher has been bought by Bloomsbury, which is a very good publisher. And they seem much more proactive in terms of trying to get books for course adoption.
Nice.
And I sold them on the idea that even though the last edition was only done in hardback, that we ought to do both a hardback and a paperback simultaneously, and that we needed to get this out in part prior to the 250th anniversary.
Absolutely.
But largely because, in 7 editions, I've never had an edition where there are so many things happening, whether it's, the choosing 2 different speakers in the House of Representatives, 4 or 5 cases involving Trump, overturning the abortion decision. This is really, I've been at this for quite a while, and I can't remember a comparable time in legal history other than perhaps 1972 to 74, maybe a year or 2 after the Watergate crisis.
With Nixon.
And what's fascinating is that, too, was right on the cusp, in this case, of the bicentennial, the 200th anniversary. And if you go back another 100 years, 1877 was a very pivotal year because we were celebrating 100 years of independence, but we also had one of the most disputed elections in American history. They actually had to set up a commission, and by one vote, they determined the election of the presidency that year. So it's
which president was it? Not many people know.
Tilden versus Samuel Tilden got the greatest number of popular votes, and Rutherford B. Hayes, I believe, is the one who actually got the vote. And there was an apparent compromise. Republicans had been reconstructing the South and had military forces there, and Hayes' forces pretty much indicated that they would withdraw Southern troops. And at that time, the Republicans, of course, were the ones on the side of Reconstruction. Lincoln had been the one to issue the Emancipation Proclamation and push for the adoption of the 13th Amendment. So there are actually some parallels there.
That we forget. I think in our time, we think this is the only time we've had this issue. This is only the only time, or the newest time since the Civil War, that we've been this divided. But I think it's good that you mentioned that, because it's not the first time, and maybe we need to go back and look and be confident that despite the issues, despite the contradictions, the disputes, that we survived.
Well, and if you go
as a country.
To throw in another date, if you go back to 1937, which would have been the 150th anniversary of the signing of the Constitution, that was the year of the so-called switch in time that saved 9, where the Supreme Court, they were being referred to as the 9 old men. They were obstructing the New Deal programs, and whether influenced by Roosevelt's threat to pack the court or whether it happened before, 1 or 2 figures on the court moved. And since that time, interestingly, the court has been less negative toward governmental regulations, but it's given much stricter scrutiny to civil issues of civil rights and civil liberties. So the major revolution in our understanding, particularly the First Amendment, and then during the Warren Court of the rights of criminal defendants, largely came after this time period.
Okay, so I love the history. I don't know it. I'm a legal buff of.
Sure you do. You took one of my classes, two of my classes.
I don't remember that. I remember how to do an opening statement. I'm a trial attorney. But I love that you're talking about it, because it goes back to your roots of your PhD in political science or political theory. Which one was it for the PhD?
Political science.
Political science. And all of your intense review and following of politics and of the Supreme Court and the cases that are coming up. And I know it's always bad to ask people's ages, and I'm not going to ask your age, but I'm afraid some of the things I might be saying might indicate your age. So
go ahead.
I'm going to go ahead. I love
My
you
birthday's
talking.
coming up on Monday.
Your
If
birthday
you
is
would like to
coming
sing
up on
gifts.
Monday. Yes. Send gifts.
Black carnations or whatever it is that you send.
No, I
Once
love
you
it.
Get to these.
Yes, your birthday's coming up, but I think it's important for people to know and understand just how entrenched you are in this in a positive way, though I don't know if Mom, you're my dad, for those of you who haven't caught on yet, of how Mom, your wife, has also been involved, voluntarily or not, that the year you got married was
the bicentennial year. Absolutely. And it would have been the bicentennial weekend, except there were so many people who had other plans that we did it a week early.
But didn't you take her as part of your honeymoon for something bicentennial related?
Well, we went to historic sites, which you'll remember. It wasn't until you and your sister got married that we realized that most people took vacations at beaches. We always thought you went to presidents' houses and historic towns.
And that is truly what we did. For someone who was raised by a political and constitutional scholar, I cannot count the number of presidents' homes we visited and national historic sites. And I really, as a kid, I was bored a lot, but we also found some things to find, interesting as well as very funny. So we did get that education that many people
our trip
didn't.
To Boston was particularly memorable.
It was.
We took you to two presidents' houses.
Yes.
The USS Constitution, Paul Revere's house.
We went on that walk, the Constitution
we traveled
walk.
the Freedom Walk, and we got back to the motel. One of you turned to the other and said, "Did you see that guy flip over the turnstile in the subway?"
That was the most exciting thing.
So we knew that we had invested our time wisely.
Yes. And the Disney World trip, the one Disney World trip we had, that we were most excited about the butter that was in the shape of Mickey Mouse.
Yes, I remember that as well.
Okay, so the bicentennial was your marriage date, and if I'm right, I know you never want to retire, but okay. I believe you mentioned to me if you retire voluntarily, and not by any other means, that it would be on that next date that you just talked about, that you would have to wait until.
But I have to. The beauty of bicentennials and celebrations is that usually the National Endowment for the Humanities will shell out a little bit extra money. There'll be some conferences. Perhaps I'll be able to give a speech or two. And I like doing that. So
yeah.
Yes.
So it's 2026. Remind us of the name of this, because it's not as easy to remember.
And I have already in my timelines in some of the books, I think I've indicated that it's the sesquicentennial. Mm-hmm. I got that, I believe, from the Latin. But I just attended a history conference, and they're calling it the semi-quincentennial. Quincentennial being 500, semi being half. And that seems to be the name for whatever reason. I guess there's some, I don't know. People seem to prefer that. I did ask several at the conference, and that seems to be what's going to happen.
Well, I love that your life events are based around these things. Okay, so
let's see. And if I wonder if I can go another 25. You know what happened on the 50th anniversary of the Declaration of Independence?
I do not.
Okay,
I know you weren't alive or around, so.
Oh, well, thank you for that. Many of my students had thought I was reporting from the paper that I had read that morning. But no, it was one of the almost providential coincidences in American history is that the two leading figures of the American Revolution died on the same day. And they were both
that's right.
John Adams and Mr. Jefferson. Both died on July 4th of 1826. And it was, it was it was sort of a unifying moment for the nation because they had worked very closely together on they were both on the committee to write the Declaration of Independence, Jefferson having taken the lead role. But subsequently, they had become bitter political enemies when Mr. Jefferson was inaugurated. Mr. Adams, now the practice that was not really established as well, but Adams did not stay for Jefferson's inauguration, nor did his son, by the way, did John Quincy Adams stay for Andrew Jackson's inauguration.
Interesting.
But almost every president has since, except Andrew Johnson, and more recently, who
Trump.
skipped the inauguration of his successor?
Trump did.
Yeah, Trump.
Interesting.
Which brings us to today's case.
It
right?
does. It does. So, and that is, and I'm trying to find the exact quote. So, you two are going to have to help me with the quotes, but it truly is a piece of history. So, with that background, even the Supreme Court. I wish I had that quote. One of you is going to have to help me with it.
Okay.
At least one of the justices said something to the effect of this ruling, this case is making history. Where they...
Any one of them could have said it.
I think it was actually Roberts, and I could be wrong. I really wish I could. But there were a couple of, things that one of the attorneys was saying, this could destroy the presidency as we know it.
Well, it could destroy the nation as we know it. If I may add a counterpoint here.
Yes.
Or the president, yeah.
Yeah, I agree. And that's what the justices seem to discuss is a lot of the conservative justices, and I want to get into more of the details. And Dr. Vile, I know you have a lot. And Chelsey, please add in. I'm more up to date on the trial as the attorney, but I love that we have
the New York trial. You mean
exactly the criminal New York trial going on right now, the hush money Stormy Daniels exciting case. But the justices, as I understand it, the conservative justices seem to be indicating through this hearing that they are more concerned about the future, not so much as this one case as to what will happen with Trump, but what will happen to the future presidency. But
I think that concern is on both sides. The two scenarios, and let's start with a caution that
Please.
I heard by a commentator last night that I thought is very useful. You have to be very careful in interpreting the questions that the court asks from the final opinion. They may, sometimes you think but you're going to ask a question on the other side, so right. we don't know how it's going to be. And I'm a little concerned that we tend to favor or disfavor the Supreme Court according to how we think they're going to rule in an individual case.
Right.
And I think we're a little too eager to attribute bad motives on the basis of who appointed whom. And I might just remind people that in U.S. versus Nixon, it's not quite the same case, but in U.S. versus Nixon, which involved whether the president could withhold tapes of conversations that he had that were relevant to illegal acts that he had committed or might have committed in the White House.
Through the Watergate scandal and cover-up.
Scandal, you actually had 8 justices, at least 3 and possibly 4. I believe Justice Rehnquist did not participate. But you had at least 3, possibly 4 justices that had been appointed by Richard Nixon who all voted against him. The court was unanimous 8-0. And so, I think a lot of people are finding the Supreme Court guilty before they've been proven guilty.
Yeah.
And I have concern. I think the concern by critics is what the court can't necessarily say, but what we all know is that the disposition of this case will affect the timing of any prosecution. If a prosecution is to occur,
Right.
There may or may not be a window for it to occur prior to the presidential election. And presumably, if it occurred prior to the election, voters would be better informed as
Right.
to the possible outcome than if it occurred later. And so there
Right.
is concern, and I have some concern here. I mean, we've talked about this before. The typical way that a case gets to the Supreme Court, it can come up through the state courts and then be appealed by the highest court in the state to the Supreme Court.
Right.
But more likely, more commonly, it starts at a U.S. district court, goes to appellate court of appeal, and then to the Supreme Court.
The normal process of appeals, right?
That's the more common process. I mean, they're both legal processes, but more typically, the court takes cases where there are different jurisdictions, particularly different circuit courts that have arrived at different decisions. We don't have that here. We have fairly strong opinions, both by Judge Chutkan, I believe it is, at the district court level,
Right.
and then by the Court of Appeals. Both of these are very strongly denying presidential immunity.
Right.
In criminal cases. Well, let's be more specific. The immunity of ex-presidents from criminal prosecutions. Both have decided, at least in this case, that there is no such immunity. And the Supreme Court could have either just said, we're not taking the case and leave them in place. Now, a reason for not doing that is when you do a book like the one that I'm revising right now, it's very rare to refer to lower court cases. We almost always, the Supreme Court is called the Supreme Court for a reason. And so it would be much more definitive if it came for the Supreme Court. But the Supreme Court seems to be dragging its feet in a fashion that might benefit Trump, which
They
is
seem to want to put it back on the lower courts.
Well,
Yeah.
right. Now, that's another issue. But I mean, even before there, the court could have expedited this. In 2000, in Bush versus Gore, the Supreme Court took a case deciding on whether one could stop vote count or vote recounts in the state of Florida.
For the
And
presidential election.
Right. And they decided it within 2 or 3 days. I mean, they expedited it. And that was an end to it. And to his credit, if I can say something for one of Tennessee's favorite sons, Al Gore Jr., who had to be very disappointed. The revoting was looking better for him than before then. He got on television and said, I don't agree with this decision, but, I believe in following the law. That's
Right.
what the court has done.
That's what they decided.
Right.
I'm stepping aside.
And of course, one signal may be, I mean, it is possible that the Supreme Court could issue a decision today or tomorrow.
Right.
And say, we've heard the case, but it doesn't seem likely, largely because typically the most important cases of a term come right at the end of June or early July, the last week or two of the court. And if you get a judgment, and particularly if you wait that long and then say, what we're going to do is kick this back to the lower court, and apparently what they're considering is, should there be a distinction between presidential official acts and presidential private acts?
Right.
And this is partly, it may overlap, but largely relates to the distinction as to whether, is it an activity that's required of a president? Does it fall under, vetoing a law or sending serving as commander in chief, or was it simply campaign related?
Which would be private.
Right. We know about the
Right.
Hatch Act. There are limits actually even to what a president can do. If he goes to give a regular speech, he goes on Air Force One and the country pays for it. If he goes to give a campaign speech, I think
It's his private jet.
The campaign has to pay for it.
You mentioned the Hatch Act. I don't think everybody does know what the Hatch Act is.
Right. Well, the Hatch Act is an act, and I don't know its direct applicability to the president, but essentially, when you're working for the government and you're on government time, you cannot use the resources of that office for election or re-election. And it was basically designed to prevent elected supervisors from putting pressure on their employees to use their work time in order to advance a campaign rather than, take care of the affairs of the city, the state, or the nation.
And let me jump in real quick here. That actually has implications even at local and state levels.
Absolutely, especially at local and state levels. Yes,
because I was
just thinking, don't you have an experience with this, Virginia? I was remembering, I was like, I think you've told me this story. Yes,
I do. I was a government employee as a prosecutor in Virginia, and in the Commonwealth of Virginia, they elect their Commonwealth attorneys, their head prosecutors. So in some states, it's called the state attorney, the state's attorney, or the district attorney. In Virginia, it's called the Commonwealth's attorney. So there's the head of each prosecutor's office in each jurisdiction. And in both of the offices where I was employed, the elections came up, right? There was an election for the Commonwealth's attorney. And there was an issue at one point in one of those offices of, okay, there's this election coming up, and where are we doing the copies of the flyers?
Yes.
Are we doing them through government paid copiers and paper? Are we doing it during the workday?
Absolutely.
Are we expecting our employees to go campaign for this person? We had some of our employees who were going door to door on the weekends. So, okay, it's weekend time. It's their own personal time. But the bigger question was, what was happening to the employees who didn't go? What was happening?
And if they were penalized, that would be in violation of the Hatch Act.
Correct. But what was a penalty?
Right.
And you could use social distancing as a non-governmental penalty that, who cares? They just don't hang out with you anymore. So there were a lot of questions locally of what time do you use? What resources do you use? Can you even use the pens in the office to be working on the campaign? Can you talk about the campaign during work time? So all of this, and I think Trump's really towed the line. This is at the very local level, but I think this is where we're getting into it. And Dr. Vile, I like that you're saying.
I think you mean the opposite, towed the line. I think you mean he may have crossed the line.
There we go. Yeah. Yeah.
If you toe the line, yeah.
True.
I think,
that he might have been okay, but then if he crossed the line.
Right.
Right. So I think in the way that you're describing it, which I think is a good description of what seems to be coming out of these arguments and what some of these justices are indicating, is if it goes down to the lower level, and if there's a question of, well, was this an official act as a president, or was this a private act as, a candidate? It takes it to a jury. That it's almost, I think it would, and Chelsey, I'm going to have you weigh in on this next, that it's not necessarily a judge decision, but that they'd have to go to some sort of trial where a jury would have to decide for each and every act. It's a factual determination that the judges don't do the factual determinations unless it's a bench trial, but that the jury deals with facts, and they'll have to decide, was this an official act or was it a private act? And weigh each one of them. And there might be, summary judgment issues where it could be said, well, legally, this clearly is as
a matter of law.
Right. As a matter of law, this is an official act. But it really goes back down to a factual question, which is a jury question. And how bogged down are we going to get if it's sent back to the lower courts and a jury or other person is going to have to weigh out how many different actions that could be contributed?
Here's where it could come back to bite Trump. that would almost be the equivalent of having a trial prior to the presidency.
Right.
Now, understand the other fact at issue here is that the Justice Department, and I'm one of the few I think who still holds out against this ruling. The Justice Department has has a policy that you will not try a sitting president. So if Trump were to be reelected, that would undoubtedly mean that no criminal prosecutions would proceed for those 4 years.
So it stayed.
Well,
Yeah.
yeah, it would be, but they could at the state level, right? That would be my understanding, is that, the Department of Justice may have a policy against not pursuing criminal prosecutions, but that doesn't really impact if we have state legislatures or state
I
prosecutors.
think it would, well, I'm not sure on that. I believe you could seek an injunction. If the state were to do that, I think you would say the same argument that the Justice Department has made. I mean, in fact, it would be even a more compelling argument because you only have one Justice Department. You have 50 possible states where you could, I think
and all their jurisdictions in the states.
Right. If the national government can't pursue a criminal prosecution during a presidency, then so much more, neither could we allow, rogue states, if you will, to do that.
Right.
But I'm not, I don't have.
I think it creates a lot of the interesting questions, but it also, I agree that it is so reflective almost. This is huge, but it's almost so reflective of these like very common legal principles. I'm in the world of, which Virginia knows, researching a lot of, is this within the scope of someone's employment? And if they're a public servant, are we really, and this is for a case in Virginia, but we're looking at, okay, well, this person is a public servant, so we don't want to, criticize every move they make in the discretion of their job, but there should be some accountability. And how do you weigh that? And do they have immunities? Do they have qualified
for
immunity?
everything?
Do they have a privileged immunity for everything? And where's that line and who gets to decide that? And I think that, hopefully these are I'm assuming the Supreme Court is thinking about things like this. If we don't want, a dictator, we have to have some accountability. But I think it's a good point. We don't want, every single jurisdiction, every single state being able to just, counting prosecutors bringing a charge against the president. Right. It does seem slightly problematic.
And can we bring up, so there's a precedent that partly applies to this case. It's a 1992, is that what we decided, decision?
I don't remember.
United States versus Fitzgerald. Or no, wait, is it Nixon versus, I believe it's Nixon versus
Fitzgerald. And that was the 70s case.
Right. So this is what basically happened in this decision is that during the Nixon administration, an administrator, someone under his employ, gave negative testimony, I believe, dealing with acquisitions of the Air Force during his tenure. And he was basically a whistleblower and was subsequently fired from his job, or the jobs were reshuffled in a way that he was no longer needed. And he brought suit against Nixon, claiming that this was a personal vendetta. It had nothing to do with his competence. It was just a way of shutting him up. And the Supreme Court decided that, okay, back up a minute, civil cases are brought by individuals.
Right.
And there's no limit. There's nothing basically to prevent an individual from raising civil suits. One penalty, by the way, which Trump has found out, is he did bring a civil suit, as I understand it, against Hillary Clinton.
Oh, right.
And lost and was ordered to pay, I believe, about $500,000 of legal fees because they said it was a frivolous suit. But nonetheless, you could imagine hundreds of thousands of individuals who might, feel embittered by some policy that, the president signed a bill that cut welfare payments and I lost welfare payments. So the question, what the court decided in this case was that the president should be immune from from actions against civil suits that had any remote relationship to his job.
Right.
Now, it
Did he
didn't
deploy the military in this action while the family members of a fallen soldier couldn't bring a case?
Right. Now, it didn't prevent Bill Clinton from being sued during his presidency for what was, and here we're back to that sort of official, unofficial acts, or, campaign acts versus governmental acts.
Right.
It doesn't, there is no duty sexually to harass someone. There is no, in my judgment, well, thanks more than my judgment, there is no official duty to submit false electors.
Right.
There is no official duty to incite people to attack a Capitol building. And again, all of this needs to be adjudicated in court.
Right.
But what people forget about Fitzgerald is it was a 5-4 decision.
Very close. I mean,
that's a majority.
But it's a split decision, essentially.
But I mean, frankly, when I read the decision, I'm not sure I would have decided for the court, because it seems there was a fairly clear personal animus by Nixon against someone else, and I'm not sure it would be much different than someone who wasn't president. But I get the point, which is, there are hundreds of thousands of people who might try to sue the president. This is not permissible. Now, yes, the conservatives have said, using the same logic, well, if anybody could bring a criminal case against the president, won't that hobble future presidents?
Right.
You'll be afraid to do anything.
That's that idea.
Although
that
if you don't
there's
do
the
anything,
future.
you might be sued for that too.
Right.
But on the other side, and this was brought out, I believe it was Ketanji Jackson, on the other side, do you want to have a president who is completely immune?
Right.
We do not have a king in the United States.
And that goes to Chelsey's point of what about a dictator?
Okay, and if we go to back to 1776, the most important work of that year, other than the Declaration of Independence, was a book published in January of 1776 by Thomas Paine, who said, kingship leads to war, it leads to oppression, hereditary succession is foolish, because in many cases, sons and daughters are not as wise as their parents. Sometimes they are. Okay, sometimes
not in every case.
Better. But, what he famously said, he actually talked about having a ceremony. Let's have a ceremony and put the charter, which had not been yet written, the Constitution, let's put a charter and put the crown on the charter, that in America, people may know that the law is king. Right. Do we want to give somebody a free pass? Now, Trump's attorneys say, we're being picked on.
Right.
There has never been a criminal prosecution of a president in U.S. history.
And that's correct.
Which must mean that we never intended to have criminal prosecutions.
The framers would have put it in the Constitution if they'd wanted it.
The more likely, but remember, the framers did not put presidential immunity in the Constitution.
Correct.
Now, they didn't put it in for judges.
They didn't say it either way.
Right. And to be very clear, judges have immunity for most of their decisions.
Most.
They don't have immunity, however, from bribery. They don't get immunity for murder. They don't get immunity for openly violating the law. But yes, some immunity is necessary probably for the proper execution of the laws.
And let me pause there and go back to Chelsey's point. I love that you brought up, Chelsey, the normal governmental immunity, because there's some immunity for government officials outside of the presidency for actions during the course of their duties. So police officers are the in this point in our history, the most common people in the news of, do you have the right to shoot somebody? The actions of, the police officers killing certain people, are they immune for any death that is caused, during arrest or after arrest? And as you're saying, in the Commonwealth of Virginia, I mean, we're even dealing with it in a civil case of the officer's actions. Is he immune just because he was an officer during the course of his employment? While in the course of his employment, while responding to an emergency, is he immune from anything that he did because it was within the course of his employment, which is governmental immunity? And there's a lot of governmental immunity, just like the president. If you send somebody to war during, the country's at war, well, that's what you can do. You're immune from suit. People can't say you shouldn't have sent my son to war. Same kind of thing with the police officers. It's everywhere in every jurisdiction. But in almost every that I know, I would say every, but I can't be sure. In almost every jurisdiction, there's an exception.
There's no
governmental immunity.
There is no absolute immunity, right? And what I think, and this is only because it's fresh on the brain, because I've been doing this research, and again, this is so fascinating that at a state level, in state courts, these cases that I'm reading, what is something that is repeated over and over and over in different ways every single time is that, specifically with the police officers, they're saying we don't want to be second guessing what are frequently decisions that have to be made on a split second with the information you have in that context. We don't want to be doing that because I think the reasoning is important here, because it's against public policy. It's not helpful to the general public. However, I think if we had an absolute immunity, that argument works there too. I don't think an absolute immunity is good for the public either. So I think we have to find something in the middle.
Who would
and we've
say?
had some prominent cases of police officers
That's where I'm headed.
of late being sent to jail for excessive force.
Would we want the George Floyd officers to be immune because they were in their duties? They were acting on the clock as governmental officers. Do we want them to be immune? No, we don't want them to be immune.
Not
the
complete.
Memphis officers who killed someone on duty, just because they're an officer working on the clock as a government employee, should they be immune from that? No one wants that. And, yes, murder, death is an easy one that everybody gets up in arms on. And Chelsey, you're right. I think the biggest issues that the jurisdictions, local jurisdictions, especially governmental immunity, is in question of, do we want officers, while they're responding to an emergency, to second guess everything that they do, to not get there in time because they're worried they might be sued for something that they do while trying to save somebody, while trying to do their duty. But at the same time, in Virginia, it's called
both ways.
Gross negligence. Yep. That if the officers acted with gross negligence while on the job, or with willful intent to commit a crime or something like that, then they're not immune. So in this way, I think the court should be looking at the normal governmental immunity for governmental employees. And what is Trump? He's a governmental employee. Let's be honest, he's paid from government funds. He is a public officer. Well, there's the question of that.
I was going to say, I think that is probably the harder question in this case, is I think because we have so much jurisprudence about what is in the scope or course of employment when it comes to a police officer, when it comes to a prosecutor, all of those types of things, we have a very clear background of what all that entails because it's been litigated for so long in state courts and federal courts. I think it gets difficult because what do you say is a presidential duty? What falls into that? And I think that is less clear.
Intervene here.
Yes,
please.
The pause.
The president does not have a duty to perpetuate himself in office through illegal means.
Right.
That is not part of the job description.
Right.
And one of the things, the court, I was always taught that the Supreme Court should address the issue before it. And I think this is an easy case. Now, Not everybody does. But he's being charged not with implementing the law, but abstracting the law.
Right.
And maybe these conservative justices, they seem to largely fall on that, who want to come up with a formula forever. Maybe that's going beyond what the facts are really going to tell you in this case. Maybe what you decide is it's not a duty of a president to try to thwart the laws of the country and the Constitution of the country. And in a case particularly involving elections, which go to the very heart of democratic Republican government, right?
Yes.
Particularly in cases involving elections,
the Democratic
we're
Republic.
going to decide that there is not presidential immunity. Now, does this mean that the president, every future president, is going to be prosecuted for something? No, it would have to be very narrow. And hopefully, right, you guys are the attorneys, we have a lot of protections that are built into the criminal justice system, probably much more than in the civil law.
Yes.
All kinds of rights to an attorney, rights to confrontation of witnesses, rights to know the charges, writs of habeas corpus. I mean, you name them. And frankly, and maybe somebody can come up with something for me, but I don't know of any president in American history who has threatened to use the Justice Department to go after his successor. Now, I know one who is saying that that's what he wants to do if he's reelected, but I think he's sui generis. I think he's one of a kind. And maybe what the court, instead of coming up with some grand scheme, is just to say, for purposes of this case, both lower courts have looked at it. They have decided that this is not a case of immunity from criminal prosecution. We will defer judgment for future cases as to whether there might one day be such an incident.
Right.
Could we have special protections against a person coming into office and trying to use, I think there are already mechanisms there. If Trump is reelected and he immediately says, well, I'm going to prosecute Joe Biden for being Joe Biden, I think that there are going to be protections in terms of, first of all, an attorney general is going to either quit or be disgraced. But I think maybe the court is trying to chew off too much. And maybe, and again, I still have my doubts about the Fitzgerald case. I feel sorry for somebody, and we now have laws, right, that protect whistleblowers.
Right.
And I think a great injustice was done to him. And yes, I don't think everybody should be able to sue a president for general policies, but if he focuses on a particular individual and does a hack job on them, I think there ought to be redress.
Right. And even I want to go to some of the statements that I've thankfully found. We had the attorney for the Department of Justice, the prosecution in this case, Michael Dreeben, I hope I'm pronouncing that correctly, even said this court has never recognized absolute criminal immunity for any public official. And that goes to what we're talking about here is the broader public official. And Dr. Weil, I like your comments, and I want to go back to those of the idea of placing the crown on the law rather than a person. And England, let's go back from there because that's where we originate and claim, that's where we came from. But we wanted to be different. They have no constitution.
Well, okay. They have no single written document.
Correct.
They have a set of procedures and customs that they follow fairly closely that is sort of an unwritten constitution.
Correct.
No, we had a written and one of the weaknesses of Trump's case is there is no presidential immunity in the Constitution. Now that doesn't mean, as we've already discussed, that there shouldn't be special protections to keep former presidents from being harassed.
Right.
But as one of the attorneys yesterday responded. He said, well, what about constitutional immunity? And he said something like, well, there is no immunity up to this point unless you give it.
Right.
And in Fitzgerald, the court made it very clear that it was not, and that's why my caution here, it made it very clear they were not then deciding the issue of criminal liability.
Right. It was
and
civil.
That's why I think the court should be able to say, and maybe they can go a little further. Maybe they can say, we're going to say for now that anything involving actions designed to thwart regular electoral processes, or maybe bribery and maybe murder, this class. And again, remember, we are dealing with a former president who has said that he could shoot somebody on Fifth Avenue
Street
and get by with it. This is an extraordinary claim. This is, I would love to think of Mr. Jefferson writing up a list of 25 charges, and one of these charges is, we have someone who wants to be reelected president who says that he could get by with murder.
Right.
If we want that, well, I'm not going to do William Lloyd Garrison. You remember what he did?
I don't remember.
He would take copies of the Constitution and burn it. He said, this is a covenant with death. I take the position of Frederick Douglass, who said, no, the Constitution actually didn't give approval to slavery. It did the best it could with the institution at the time. I would like to think, and I believe I have good reason to think, that I know that the founders did not create a kingship.
Right.
There are all kinds of checks and balances.
They went away from that. That was the purpose of America, was to get away from what, King George?
Right. And actually, in fairness to King George III, he acted perhaps tyrannically toward the colonies, although Parliament had more to do with it than he did. But he actually did not, as I understand it, act tyrannically over his own people. It was more a matter of foreign policy than it was domestic policy.
But the important point was, it was a person who was ruling and making judgments for the entire country rather than the law and the checks and balances. And that's what they wanted to go against. Let's think about England. Henry. Is it Henry IV, Henry V? I'm terrible at the names. With all those wives, and he completely changed.
Henry VIII.
King Henry VIII.
I am.
Was
I
it?
am.
How many?
Married, beheaded, died. Married, beheaded, survived.
Yes,
something like
you
that.
got it.
Yeah, look at that.
He was allowed to do that because he was king. He was the one making the decisions. So he changed the whole religion for the country. How many rulers, kings, dictators, whatever, the Crusades. They said, go on the Crusades. They made that. And, in
earlier.
France, the guillotines, how many people did the king decide? It was the king's decision. And we went away from that.
Okay, let me stop you there.
I'm so sorry.
The
Go ahead.
guillotine, I think, was the revolutionary government. It was the king and queen who were actually...
Well, I mean, they were killed by the guillotine, but...
Yeah, I don't know that the king had guillotine that many people.
But I think your point stands, the idea that we have historical context for what it looks like when we have this prevailing doctrine of rules for thee and not me, and what that looks like throughout history. It's not good. It's not great. And I definitely think the founders didn't intend it for America. And I think that it would be hard for me to conceptualize what that would look like in this country. And I have my thoughts about the people who are on the Supreme Court right now. Outside of those, I do think, whether or not we agree on what that looks like, they do want the best things for this country. And I do think they're smart enough to, as Dr. Vile was saying, to narrow the decision they make, hopefully in a way where it does not become this all-sweeping precedent that is either going to make or break what the judicial future of the country looks like. I hope they're able to tailor it in a way that fits the situation at hand. And hopefully does not become this legislating from the bench type of decision.
I do think my hope is a little bit different, but it's similar. I hope they do make it clear that there is not absolute criminal immunity. Now, I think they can say if there is ever an example of such a case that where you would not be immune, it would be dealing with who your successor is. Anything related to elections.
Yeah.
And I think if they want to throw in just for good measure
murder
on Fifth Avenue or the like, I think that would be fine. But I don't think they need to decide at this point in great detail. Let's, if you want to turn Trump's arguments against him, the fact that we've gone 200 years or better without ever having an indictment suggests that it's very unlikely that people are going to use this mechanism. They're going to be laughed out of court or, dismissed and maybe charge lawyers' fees for it.
Right.
So it may be, it's like Lincoln's example of the person who comes to court for murdering his parents and he claims for clemency that he's an orphan. Here you have a president who has defied every norm, who has indicated that he would hopes to prosecute, and actually did try to prosecute someone who ran or bring a civil suit against somebody who ran against him. I don't know that we want to make all American law based on this one person. Let's take care of this exception and then, let it play out.
And I think to your earlier point that you said, we do have mechanisms in place, especially in the criminal legal system. And there was some back and forth at the oral arguments about what a grand jury will or will not do, which I thought was a fascinating sort of criticism that, they'll indict a ham sandwich. It's a quote, the whole thing. But I'm like, to hear a Supreme Court justice say that as if we're questioning what grand juries are doing all over the country all the time was shocking to me, especially coming from the justice it came from. But I think that's a good point. It's like, we're not talking, I understand, especially on the civil level, we don't want every person, and we've seen some crazies out there who would just be filing suits constantly, like pro se litigants, all of that. I certainly get that, but I think that there is a way to say we kind of have mechanisms in place that it shouldn't be so easy to prosecute anybody, to include a former president. That why does this have to be so different?
Right, and I'm concerned. I continue to go back to the idea of the political rivals, and that's what you both are mentioning. Is we're not Russia and the Soviet Union. I mean, we're not Stalin. We don't want a Stalin. We don't want a Putin who will kill political rivals. And not to say that Trump has said he'll kill political rivals, but he has said, I'll bring retribution against anyone who came after me. Is that really what we want? Is someone who will personally decide that the political rivals who proceeded through our democracy, our democratic republic, with the rules that we have, with the laws that we have, that they should be, prosecuted or done away with? Should he be allowed to murder someone on the street? And the interesting part is Justice Kagan asked this part. She asked Trump's attorney Sauer whether a president would be immune from ordering the military to launch a coup. And he said, well, there would be immunity, but only with, impeachment. And it's like, do we want, this is linen.
If your coup has already occurred, who's going to impeach?
Right. They've taken over the government. Are we linen taking over the crown, completely eliminating the government as we know it and ruling as one leader? This is the whole idea of what we tried to prevent. We don't want coups. We want democracy. We want elections. We want the people to decide, not one person to do this coup. There was another one, in the lower court arguments of, he can.
And this came up again in the SEAL, Navy SEAL thing, right?
Yes, that's exactly right. So if someone can help me with that quote better, is, the lower court arguments on appeal was Trump's team said, yes, if he orders a Navy SEAL, team to go assassinate his rival, then that's okay. He should be immune from that. But this goes back to the tyrannical governments to me. of not the democracy. We aren't supposed to be killing our political rivals. We aren't supposed to be using government officials to do that or to go after those who oppose us. The Democratic Republic, we don't have to like it. We can run against them. We can say bad things about them under the First Amendment, but we're not supposed to be doing that type of retribution, according to what I understand of the law, unless we are trying to have a government that looks more like Russia, that looks more like the original kings, that looks more like these African governments. I mean,
and it's going to sound partisan, but we have a candidate who constantly praises Putin.
Yes.
I mean, what other U.S., we have been in bed with lots of dictators, particularly during the Cold War,
Right.
because they were enemies of our enemy and they became our friend. But we have never positively, we don't go out and praise them.
Right.
We recognize it's, a marriage of convenience or whatever it is. We have someone running for the presidency who praises Erdogan, praises
Right.
Putin, and praises the head of Hungary and on and on.
Right.
And we really are. I mean, this decision, it could be very, very consequential.
Agreed. And Justice Sotomayor, she also questioned this immunity issue and asked, one of her questions to Trump's counsel was, if the president decides, this is similar to the coup, and exactly what we're talking about. She said, if the president decides that his rival is a corrupt person and orders the military or orders someone to assassinate him, is that within his official acts for which he can get immunity? Trump's lawyer responded, it depends.
Yeah, which is ridiculous. I mean, an attorney needs to know when to give it up, obviously, but they've. The problem is they should not have asked for absolute immunity.
Right.
I mean,
and they
should have said,
they're throwing their hat in with this.
Right. Absolute immunity. I mean, that's, yeah.
And Sotomayor, she summed up the argument, and she stated, so what you're saying is, quote, a president is entitled to total personal gain to use the trappings of his office, that's what you're trying to get us to hold, without facing criminal liability. Now, let me ask you this, Dr. Weil. Justice Sotomayor and Justice Kagan, are they considered conservative or liberal justices?
You're generally considered to be liberal.
Who are the...
Along with Jackson.
That's what my next question was. Who is the other liberal justices?
Three women, actually, sort of by coincidence, that all three are women, But yes, they tend to be on the liberal side.
And who are, we've got 9, so that's 3. Who is there anyone else on what we consider the liberal side? Or the rest of them gone?
Not. I mean, they
Breyer's gone.
Pardon? Yeah.
Breyer's not there anymore. So what about the conservative side? Are they all the rest of the 6 conservatives?
Well, no, I think Thomas probably the most, Alito, Gorsuch probably.
And I think it was Roberts who said, this is historic. This is, monumental. What we decide is making history.
And people, now we mentioned Fitzgerald as a 5-4 decision.
Right.
But frankly, I mean, the stakes were high for Fitzgerald, but the stakes for the nation were not nearly as high in Fitzgerald as they are right now. And usually, if you go to U.S. versus Nixon, it was 8-0 on the tapes case. Yeah. If you go to Brown versus Board of Education, doesn't deal with the presidency, but, one of the most consequential decisions in our history, recent history, it was a 9-0 decision.
Which held what? Give us the holding of that one.
Well, that was a decision that overturned legalized racial segregation.
Okay.
Yeah.
So generally on these high profile cases, you can expect that if the chief is in the majority, he will almost certainly write the decision. And it may very well be, I mean, maybe what I've suggested will work here. Maybe the compromise is let's just decide, can we all agree that a president, if he has violated criminal law related to elections of his successor or not, can we agree that that would be something you can be criminally prosecuted for?
That he's not immune for that. There's no
right.
absolute
He's not immune
immunity
for that. And let's defer these other decisions. I think you might be able to get a majority on that.
Mhm.
But, if you went simply by the questions yesterday, there's basically sort of a 6-3 conservative majority. But again, if you remember in the Dobbs case, am I right?
The abortion case, the recent
Yeah.
abortion case.
Mhm.
Roberts doesn't go all the way in on that decision. He's he's closer to the middle. Of
Yes.
all the justices there, he's the one that you might expect to pay the greatest attention to the institutional sanctity
Mechanism.
isn't quite the right word, but the importance of preserving the institution is one that we consider to be fair.
Yeah.
And that would
Yeah.
caution. I mean, if they issue a decision that says the president is completely immune, I'm going to be among those who say, okay, I'm really coming late to this party, but I'm going to have to agree that the Supreme Court has become so partisan that we no longer can trust it.
I'm going to move to
But
Canada.
it becomes, pardon?
Yeah.
I'm going to move to Canada.
Yeah, well,
Hey, I think we should just stop it up. Say, you know what? Let's get rid of the conversations about immunities. If you can get an indictment, you can get an indictment. However, you can have an affirmative defense of presidential action. Put it like self-defense. Okay, you
Right.
can assert an
Interesting.
affirmative defense. And if a fact finder,
Fascinating.
a jury, or you have a bench trial, and you want to bring that defense as an option and they believe it, you're good. I think
it's
that's how we
almost
fix
as
it.
yeah.
Mm.
I don't know that you can get much higher a standard than not beyond
Reasonable doubt.
reasonable doubt. But yeah, it's almost like in a case of a president, this is not an action that we would take easily. But
Right.
the king is not above the law. First of all, we don't
Yes.
have a king, and even if
Right.
we did have a king, he would not be above the law.
Right.
Yeah.
And I like that you both are saying this. Let's talk about Chief Justice John Roberts. Dr. Vile, let me ask you a quick question, and then I've got some follow-up. He's in the conservative part, right? The conservative 6, but more central.
Well, I mean, to take the most obvious case, I believe he was the deciding vote and perhaps the person who wrote the decisions and the 2 decisions that have upheld Obamacare, or what's the real name for it?
That's all I know it by.
Okay,
It's terrible.
It has a more formal name.
It does.
He was the one who sort of split the difference and said it may not fit under the Commerce Clause, but yes, it fits under this other clause. And so he has been one who has, I think, moved a bit to the middle. And again, all the justices should be concerned about the institution.
Right.
But particularly if you're Chief Justice, you don't want to be known as the last Chief Justice, right? You're the one who the court, got so out of kilter with public opinion that they added
dismantled.
4. I mean, what'd be more likely? We probably wouldn't get rid of the court, but
more stacking.
Right. I mean, there's no constitutional requirement that there only be 9 justices, and we've had. And, and this is, if you think about it, this is a restraint on the court.
Mm-hmm.
Now, the one issue we haven't mentioned here, which goes back to another case, is impeachment. Now, what Trump's attorneys, having said that they've argued for absolute immunity, they do recognize one political check, which is impeachment and
by
conviction.
Congress. Mm-hmm.
Right. The problem, of course, is for some of these things, if it actually changed the election, you could have people, or if there were an actual coup, you could have people so frightened
they all vote for it.
But even before that, I mean, we've had okay, let's see. Johnson, Clinton, and Trump twice. We've had 4 presidential impeachments and no convictions.
Right.
We have never had a conviction and removal of a U.S. Supreme Court justice. Now
and that would be under the Constitution for high crimes and misdemeanors.
Well, treason, bribery, or other high crimes and misdemeanors. That's right.
And the defense is saying, well, if Congress decides that a president hasn't done that, then he's immune.
Right. Well, right. What they are saying, I mean, it's a very bizarre argument, and to my knowledge has never been made prior to the Trump administration, which is they claim that since he was impeached and not convicted, that means he can't be prosecuted. But when he was impeached and he had the trial before the Senate, the argument that his attorneys made was you don't have to convict. He is still subject to criminal prosecution.
Right.
So you have, you're close to this example of the Lincoln example of claiming to be an orphan. He's argued both sides of this.
Right. He wants one in one situation and another in the other. So let me bring up Roberts, and then let me bring up another idea. So Roberts in the centralized, and Dr. Vial, you mentioned that he really wants to uphold the institutions that we have. I like that he basically asked the state, the DOJ attorney, Dreeben. He asked whether they're appropriate. This is so spot on with what you're saying. Whether there are appropriate safeguards in place, assuming through our regular systems and laws, to prevent politically motivated prosecution of former presidents, if the courts hold that there's no absolute immunity. Now, Attorney Dreeben said, quote, "We are not endorsing a regime that we think would expose former presidents to criminal prosecutions in bad faith for political animus without adequate evidence. A politically driven prosecution would violate the Constitution." So this exchange between Roberts and the DOJ attorney is basically like, no, we do have those systems. We do have laws in place where you can't just prosecute willy-nilly. I hate using that term, but that's essentially what it is. You can't prosecute for any reason. You can't put, that's why Trump's team was fined by the court, where they said, you're bringing a frivolous lawsuit, so we're going to fine you and make you pay for it. So they're going back to, we have structures in place. We have laws in place that are supposed to prevent this and to sanction if it's done. Now, let me go to it, with that said, I've been dying to give this example, and hopefully it's appropriate here, and hopefully I say it right. With all of Trump's arguments and his attorney's arguments on his behalf for absolute immunity, and yes, if he wants to, do a coup, blah, 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 etc., I cannot imagine that if Biden decided to send a SEAL team to eliminate Trump, his political rival, while he's still president, that Trump and his team or anyone associated with that would think that that was okay. So it's what's good for the goose is good for the gander. Is, he wants to be able to, prosecute or eliminate any public, political rival through, whichever means. I'm not saying he wants to murder anyone, but the argument by his attorney was, yeah, he should be able to eliminate a rival through the SEAL team or through, a coup can happen. Is that argument would work on behalf of Joe Biden? As president, as current president, or whoever it is, would be allowed to do the same thing, but surely not, Trump's team would say. It's only me, I can do that, but you can't do that. I can't believe that he would be okay with that. And the other idea of this kingship and this idea that one person has so much power and authority, Dr. Vial, let's go back to, FDR. When FDR was elected to a third term, the history of it, but people revolted. We shouldn't have a president this powerful that he continues to hold sway. We want a president to only have 2 terms. And
we
an
subsequently
amendment.
adopted an amendment.
We got a whole amendment that the government, the people, sided with an entire amendment, and we've only had 23, 25. I can't remember how many there are. How many? 27. We've only had, in how many years? Hundreds of years, 27 amendments. And one of them was essentially to prevent kingship, to make sure that FDR did not have another term, and that presidents could only have 2 terms for 8 years. And in my mind, that history is we are limiting the power of one person.
Okay. And to be clear, Roosevelt was not president when it was adopted.
Right. Agreed.
It was a very partisan, it was primarily supported by Republicans who had, Roosevelt, of course, eventually was elected 4 times. But yes.
He didn't serve the 4th term. He died.
No, that's right. That's right. And actually, Mr. Jefferson had one of his objections to the original Constitution was he thought there should be term limits.
And we have term limits on governors. And, there are limits. And the idea behind this, under my understanding, is to limit the power of one person. And what I believe Trump is arguing is, well, give me more power. Give one person more power, but only me.
And, it is fascinating. If you look at the structure of the Constitution, legislative powers are limited to the powers herein granted. And presidential powers don't have that specific phrase in there because it was recognized that we wanted an energetic president, particularly, and this might be another distinction that the court could draw. I think they might very well make a distinction between domestic and foreign matters. I think a president needs greater discretion over foreign enemies than he does over domestic rivals.
Right.
But, we've recognized wide presidential powers, but to take a clear example, when President Truman seized the steel mills during the Korean War to stop a strike, the court stepped in and said, no, you don't have congressional authorization to do this. You've acted beyond your powers.
There are limits.
Right. When Nixon tried to withhold tapes, the court stepped in and said, no, that's not, they're public property. And there have been similar decisions. We don't give, to go to, we're talking a lot about kings, but much of the American Revolution, which we'll soon re-celebrate, dealt with parliamentary power.
Right.
And the theory of the British Parliament was parliamentary sovereignty, which was Parliament can do anything other than that which is not naturally impossible. At the time, it was sex change. Modern medicine has since intervened.
Sure.
But the colonies, when they rejected parliamentary taxation, it was like whatever rights you have in England, you don't have the rights to tax us when we're not represented there.
Right. Taxation without representation.
Yes.
I mean, this is the Boston Tea Party?
Yeah, among other things.
We have 3 branches of government and we limit the power of each branch so one is not more powerful than the other. This is the checks and balances.
We divide the Congress into 2 parts.
Yes.
For the 2 houses for the same reason. We have federalism for the same reason. States continue to retain some of their power. We have a mix of elected and appointed officials.
Right.
We have all kinds of checks and balances. And again, what's extraordinary, I think it speaks hopefully to the character of most people who have been presidents, that this is the first who's facing criminal prosecution.
Right.
We're not used to electing presidents who we later have to decide whether or not they committed criminal acts when they were in office.
Right.
Hopefully we won't have to again.
Okay, so it sounds like Dr. Vile, I don't want to sum up like Sotomayor. She's much better than me. So Dr. Vile, I want to go to you first as to what you think will happen. Chelsey, I want to go to you next, and then I'm going to throw out my my poor humble opinion. Go
I
ahead.
don't like the prognostication very well. I think
You've already done some. Go for it. What do you want to happen? Go for that instead of what you think.
I think it is absolutely ridiculous to think that a president or any figure has absolute immunity from criminal prosecution. I think in this case, the court should say if there is ever an example of a case where a president should not have criminal immunity, it would be in cases where there are strong indications that he act not to facilitate the execution of laws, but to stop the laws. And if they want to throw in murder and a couple other examples, that would be fine with me. But I don't think they need to decide every possible immunity situation that might arise. Stick with the case at hand, and it is pretty clear. And anytime you have an attorney and you ask them, well, what in this hypothetical, and they say they give a reason, they give an absurd answer, the appropriate response is probably to say, we've heard all we need to hear. We'll give you a decision tomorrow.
Chelsey, either or both. What you predict will happen or what you want to happen, or both?
I'll do both just because, I like to hear the sound of my own voice, clearly. But I think what I hope will happen, which I know is not going to happen, and no one is going to be surprised to hear me say this. I think if you've listened to any of the episodes for any length of time, I would be perfectly happy to get rid of all immunity for public servants, which I know is opening up I get it. It's Pandora's box. But I would be on the favor of do what you need to do, even in the context of your job, and stand on it. And if you can't, maybe don't do it. Nobody's going to be surprised to hear that I'm being very overbroad. I understand there's lots of nuances and complications here, but I'll stand by that. I would love for that to end. However, what I think is going to happen is that they are going to, I don't think they're going to give him full immunity from anything he did in the course of presidential. But I do think what will end up happening is they create precedent that will continue to be used in the future, that I'm scared about what that looks like. Hopefully, we just won't have a president who's committing crimes again.
Yeah, I mean, and that's the hope. And we don't know that he has committed crimes. And I think that's why the prosecution is so essential of a jury through the processes that we have legally will decide that. It's not up to public opinion. It's up to our normal legal processes. I have my own opinions. I'm not a juror. There's a reason I'm not a juror.
Let's hear it.
So I struggle with sovereign immunity. That's the word for it. Governmental or sovereign immunity. I struggle with it. My husband's a former police officer. I was a prosecutor who dealt with, police officers, detectives, all, different FBI organizations and entities. So I see on a personal level the need that we should have some immunity. And in Maryland, I live in Maryland in Montgomery County, and there's been a lot of, move to defund the police. There's been a move within our county to get rid of completely sovereign immunity for police officers. And we've seen 7 police officers apply, 7 people apply to be police officers. We've seen such a large increase in officers leaving. And we don't have in our county, in Montgomery County in Maryland, we don't have enough people applying to be officers to cover the gap of everyone who's leaving. And a lot of the reason they're leaving is they're so afraid that they will be sued or prosecuted for anything that they choose to do in an emergency situation. They don't want to even respond. Why go to that if you might be prosecuted if something happens? So we have this huge gap, and we have a problem of if you get rid of immunity completely. I do believe that there should be some exceptions. I absolutely believe there should be exceptions to governmental immunity. I believe that should be applied to presidency, which is a governmental entity and institution, as well as our normal, governors, our public, other public officials, that he should be required. He is the executive branch. And as I understand the Constitution, it is his duty to enforce the law. That's my understanding of the Constitution. So what I believe should happen in this case is that they should hold him to that, where if he is not acting to enforce the laws of the United States, then he is not acting within his presidential powers and is not immune from criminal prosecution. I believe he should have some immunity. I don't believe it should be absolute, but I believe he should have some. Just like police officers. The
constitutional language actually says he shall execute the law. And it's apparently two different interpretations of what execute means.
Right. What does execute mean? Right. True. But I believe if you're tasked by the Constitution to execute the law, that is the purpose of the executive power, the presidential power, that it has limits. According to the Constitution, these checks and balances, it is not all powerful. And if there are constitutional limits on the presidency, then there should be criminal limits on the presidency, but it should not be all powerful. So I believe there should be some immunity, but I believe that the Supreme Court should say there's not absolute immunity. And if he is acting outside of the law, if he is acting in a criminal fashion to thwart the law he is supposed to uphold, then that is not immune. Those acts are not immune. If he is acting outside of his duties in the employment as a government official, that campaign, I hope and would love to see them say campaign activities are not presidential activities. They are not official acts and duties. If you are campaigning, whether you are or not a sitting president, that those are private individual activities and those are not immune. I would love for them to do that. I don't know that they're going to want to go that far. Dr. Vile, I think Go ahead.
Do you want to tell us what's fueled your thoughts today? Mine was A&W root beer.
Oh, yes,
I don't think you've introduced this.
We never talked about the wine. This is such an interesting topic. We got all excited and passed. So because we're doing this right after the episode about Trump's criminal trial in New York for week 2, do catch that episode and follow the legal issues for week 2 of that jury trial. I brought back the Dark Horse. The Dark Horse Cabernet Sauvignon. Yeah. So that's what I'm drinking. And that's what I'm fueled by. And the more that I finish this glass, the more excited that I'm getting. So thank you for reminding us. Dr. Val, I don't think you're on any kind of wine or caffeine.
No. A&W root beer, I believe, is caffeine free.
Caffeine free.
Yeah.
It's
tasty.
It's tasty. I wish you had some ice cream with it. That's how I enjoy my root beer.
Yes, I like that.
The floats. Chelsey, what are you drinking today?
Unsurprisingly, back at it with the Franzia boxed wine. They need to sponsor me. I'm telling you, because I am obsessed with every flavor. Franzia boxed wine is where it's at. I'm back at it with the Moscato today. Like I said, it's been so hot here that I just am very into very, very sweet, light white wines currently.
Well, I love that thought because I if anybody wants to sponsor us, please let us know. We would love to be. We love our own, the sound of our own voices and our own opinions, but we hope you like it too. We hope you're finding it enjoyable, whether you're yelling at us or applauding with us. At least it be interesting and something you're enjoying. Please remember to click like and subscribe to follow, whether it's through the audio podcast or through the YouTube podcast. Don't forget to check us out on thelawunscripted.com, where you can find these free resources as well as the bar and law review classes. And, if you want to suggest a wine or send a bottle of wine for us to try, please do that.
Or drop your predictions. I want to know what other people's predictions are. Let's see.
It's going to be a smirconish.com where we take a poll every week.
Yes.
Oh my goodness.
Actually, I'm secretly a bookie and I'm going to, run bets on the Supreme Court decisions.
We'll all be prosecuted. Forget Trump. It's going to be us. I think it is interesting. I think it's the predictions are interesting. I am on the seat of, we all are on the seat of, our chairs waiting for this decision. And I wish, Dr. Violet, was the Bush versus Gore where it's out the next day. But it hasn't been, because it's the next day and it's still not out now. We're not at the end of the close of business when we have made this podcast. So please understand.
Highly unlikely it's going to be decided.
Yeah. I mean, the conflict, the contempt issue hasn't even been decided by the New York judge for Trump. So I don't think the Supreme Court decision will be. But follow us. Please continue to follow us. We're going to do 2 a week, at least one to follow each week of the criminal trial for Donald Trump, and another to cover another issue. It may be Trump related. Hopefully, we're trying to get the abortion issues in. We're trying to get a lot of the other legal issues that are coming
There's
out.
There's a lot happening.
Oh my goodness. We can't catch up. Unless we do this full time, but we're not sponsored. We're not making any money off the podcast. It's just us enjoying our time. So if you enjoy us, click like and subscribe, and we will catch you next time on the Legal Weekly Wine.